Welcome, everyone. Thank you for joining us at the third information session on the proposed judicial implementation of mediation. It is an absolute privilege to share the next 45 minutes to an hour with legal practitioners, candidate legal practitioners, and all attendees. I would like to remind everyone that this information session is being recorded, and in all probability, it will be uploaded to YouTube. Accordingly, I will kindly request that all attendees be mindful with their questions, comments, and statements. However, please take the liberty of asking relevant questions when we reach the Q&A section. My name is Yusuf Wadi. I'm currently serving as the chairperson of the Gauteng Attorneys Association. I'm also a member of Nadal Johannesburg, Soweto Legal Fraternity, and also an executive member of the Johannesburg Attorneys Association. We have with us, as part of the GAA Executive Committee, Conrad van der Vyver, head of the RAF Committee and executive member of both the GAA, PAA, and a committee member of the LSSA. We have Marianne Pretorius, the vice chair of the GAA. She's also the secretariat of the EEC meetings and chairperson of the West Rand Legal Practitioners Association. We have Nicolette de Wit, the secretary and our own little miracle worker of the GAA. She's also part of the High Court Committee and is also a mediator. The agenda for today, as circulated, is as follows. We'll be having a brief introduction. We'll be then dealing with the Training Academy, Mediation in Motion training. We will then talk about the Mediation in Motion model, and then we'll have Q&A. And once we're done with Q&A, we'll then move for closure. So as we all know, the Gauteng Attorneys Association, which is our provincial umbrella body, when local attorneys associations, being the GAA, PAA, West Rand Legal Practitioners Association, the Soweto Legal Fraternity, all form the Gauteng Attorneys Association. These associations play a vital role in each region, and by being a member in good standing in any of these associations, members fall under the umbrella of the GAA. We have hosted 2 previous information sessions, and we undertook to provide legal practitioners insight to any information that is provided to the associations and to arrange this updated information seminar stroke workshop. In today's session, we have the privilege to welcome the Training Academy, that is Mediation in Motion Training Pty Limited. This entity provides training and accreditation in collaboration with the University of Cape Town, that's Law at Work, for professional development programs. We would also like to welcome Mediation in Motion Mediators NPC. This organization and its members are duly accredited mediators, having completed training, and they continue to provide support in this sphere. Must be noted that SAMLA, ADR Technology Group, and Conflict Dynamics were also part of the original organizations that were all consulted by the judiciary. Today we have Daniel Nelson of Mediation in Motion Training and Michiel Bauer of Mediation in Motion Mediators NPC. And they've kindly agreed to provide the information which shall assist all of us moving forward. So without further ado, I'm going to be moving into the Training Academy first, Mediation in Motion training. I want to call upon Daniel Nelson to provide us with a brief introduction of both himself. Daniel, if that's okay, I prefer you giving us your own CV rather than one of us reading it out to you, the platform, and also an opportunity to talk to us about mediation in motion, the training facilities, etc. Daniel, I'll hand it over to you.
Thank you very much, Yusuf, for this opportunity. I am honored to be here and speak in front of a distinguished group such as yourselves. I saw a couple of people that have actually attended training from us, so it's always an honor to meet up with all delegates again. As you said, my name is Daniel Nelson. I'm a mediator. I was qualified as a mediator in 2012, done courses in mediation subsequent to that, as well as attended or completed negotiation skills training at Harvard in Boston. And I've been operating as a mediator and trainer since 2012 and 2014, respectively. The organization I represent is called Mediation Training. We were founded in 2012, myself and Advocate Alan Nelson SC, and have been presenting training under the auspices of the University of Cape Town since 2014. To my knowledge, we were the first university-accredited mediation training course, and at present, I think we're still the only ones offering a mediation training course that is endorsed by a university in South Africa. Now, there are other international companies that have got universities that they work with overseas, but at the moment, I think we are the only one working with university, definitely the University of Cape Town. We've been presenting mediation training since 2014, as I said, in different spheres. We started off with commercial mediation training, commercial and workplace mediation training, I should say. Then started specializing in different spheres as the needs arose. We started specializing in mediation training in the transport industry, the medical industry. We started creating specialized courses for various industries, including for legal professions, advocates, attorneys, and other qualified professionals. I think it's one of the only training courses in South Africa that specializes in mediation that runs for 1 week, 60 hours. It's an extremely grueling course, but it covers a lot more for the legal professionals than just specializing in one field or just a very general overview in mediation. Now, that being said, mediation skills remain fairly the same as you cross all the different spectrums of where you can apply mediation. The fundamental skills stay the same. The areas of specialization, for instance, when we do the legal professionals course, we focus on medical, we focus on RAF, we focus on commercial matters, as well as a couple of other spheres. In order for them, the delegates attend, get an insight into the complexity of different matters. Now, the dynamics in the RAF matter is completely different to the dynamics in a commercial matter, if you want to call it that, or a medical matter for that matter. So the legal professionals, we try and cover all of the spheres, so when they go out there, they can go and specialize in fields that they've already been working in. For instance, if you are interested in RAF matters and you've been doing RAF matters for a long time, you'll understand the dynamics that's involved there. And it's going to be completely different than to dealing with a medical negligence matter, as I said. Our trainers, we make use of a vast, diverse group of trainers, and it might change up depending on the matters that we're dealing with. If it's a specialization in the transport field, we might be using different trainers and coaches during those matters, or versus medical matters or anything else. The core group consists of Advocate Alan Nelson SC, Professor Johan Wolters, who used to be the head of orthopedics at Gauteng and was professor at UCT for many years. Oscar Sawale, which is, he has been mediating since the late 80s, early 90s, and has been presenting training in mediation since the early 90s. Very specialized. He's the head of an organization called SADRA. We're honored to work with them as well. Includes myself as one of the trainers, and we've got lots of coaches that come in depending on the speciality, the type of course that we are presenting at that stage. What happens with our courses that maybe is a little bit different to other courses is we do a theoretical part, if you want to. Yes, we do cover all the theory behind mediation.
Sorry, Chair and Daniel. Sorry,
yes.
I'm sorry to interrupt, but I think a couple of people are experiencing a sound problem. I don't know if it's for everybody.
Okay.
But can we just ask that that be checked? Thanks.
Okay, let me just switch headphones if you don't mind. Hopefully that'll improve it.
Yeah, thank you.
Daniel, you want to try that out?
Okay, is my sound better now?
Significantly
better.
better. Thank you.
Okay.
Please,
Should I start from the beginning, or should I just proceed?
I think you can just proceed. It was just crackling, but we got. Thank you.
Okay, I'm sorry about that. I didn't know my sound was bad. It was working fine this morning. That's unfortunate. So we've got a diverse group of trainers and coaches that we make use of. Now, as I said, we start off with the theoretical part and we quickly start moving into practical applications of the theory. So that by the end of the 5 days of training, people have got a grasp of the process and how it works. And it is, we specialize in facilitative mediation and not adjudicative mediation. And that process, the two mediation processes are fundamentally different. And there are various skills that you need to acquire and demonstrate by the Friday in order to get there. Now, we've got coaches sitting in, and as the week progresses, the groups get smaller and smaller. And we've got coaches in the beginning for every group of 6 that we are dealing with. So you can imagine it's a fairly intensive process where we can really help you hone your skills as a mediator. And everybody has got certain skills that they can apply to mediation. We're going to train you in the ones that you're lacking, and we're going to praise you for the ones that you already have. Now, when it comes to facilitative mediation, it is different to adjudicative mediations. We are not there, and the rules actually dictate that we put out for our mediators and that they've got to adhere to if they want to belong to organizations like Mediation in Motion Mediators, is that you are not allowed to give advice. So you can't give legal advice even if you are an absolute specialist in your field. You are not allowed to give legal advice if you are acting as the mediator in the matter. You're also not allowed to make awards, decide who's right and who's wrong. So the mediation process is basically a process that we get parties to come up with their own solution, their own agreement. And what we have found is that is a much more workable solution for them as time goes on. They try to adhere to that because they take ownership of the solution that they've generated to the problem. Now, I just want to run through a couple of the key differences. And a lot of people think, oh, I can mediate because I can negotiate. Now, there are fundamental differences between negotiation and mediation. The first fundamental difference is that in mediation, we will focus on the parties. Their legal teams will take a little bit of a back seat, even though they are vitally important during the mediation process, and they must understand the process in order to be able to assist their parties in the process. Rather than quite often what happens is you'll be involved in those quite often is the negotiation. I almost want to say on the steps of the court. It's a negotiation process during the litigation process, and they end up being more centered around the attorneys negotiating with each other. So it's via proxy, I would say, where in mediation we really have focus on the parties and discover their needs, interests, and concerns that need to be addressed. Forward-looking, future-looking. Now, on both sides, when we start off the process, negotiation and mediation, parties are positional, and you can call them demands, are born out of their positions. Now, in straight up negotiation, that stays fairly fixed. It's not dynamic, it doesn't shift. In mediation, as a mediator, we expect the mediator to be able to shift parties' positions. And there's lots of different skills that you need to pick up in order to be able to do that effectively. And along with fixing or shifting the party's position, we get something in negotiation called the fixed pie perspective. The pie is only this big, and you can only divide it so many ways in order to please everybody around. In mediation, we don't see something like the fixed pie perspective. We see something that the size of that pie can increase. We can add value as mediators. We can extract value from the parties to bring to that pie in order to make it bigger. And at the end of the day, a small portion of a massive pie is a lot more valuable than a big portion of a very small pie. So in negotiation, we stuck with a fixed pie perspective. In mediation, we know that is going to be variable. Now, in straight up negotiation, it's not impossible to negotiate during conflict. It is just a little bit more difficult. Now, the matters that you're going to be facing with, there's going to be conflict 99% of the time. And it is very difficult to negotiate during that process. Whereas in mediation, that is not a problem at all. It's actually, we enjoy seeing conflict because that means that there's certain things that can be fixed. And if those things start getting fixed and start getting addressed, the possibilities of solution get expanded astronomically. We also have something called the zone of possible agreement. Now, in negotiation, it is normally fixed, and it's very difficult to move the zone of possible agreement. Now, zone of possible agreement is very simple. It's an area that people can find a solution. If you speak up in monetary terms, it's say between 95,000 and 100,000. They can find a solution anywhere between there. But if the one person will take as a minimum 150,000 Rand and the other one will offer as a maximum 100,000 Rand, there's a 50,000 Rand disparity and there's no overlap. So there's no zone of possible agreement. Now, in negotiation, this is fixed normally. It's born out of their positions, and because their positions never change, it's very fixed. Where in mediation, it is not fixed. It is kind of flexible and it is dynamic and it changes the whole time. What we kind of often find is that a lot of conflict is born out of something that we call a dignity violation. It's somebody who feels that the other person did him in. It's a affront on their dignity per se. And in straight up negotiations, those never get addressed. In mediation, this is one of our focus points, is to go and have this dignity violation addressed. Can be done in various ways, and it depends on the dignity violation, before we even get to generating options and putting forward proposals from one party to another party. And what we have found is sometimes you actually end up mediating, you address these dignity violations that parties have got, and they don't settle that day because you ran out of time. But you've moved them to a point where they can start constructively dealing with what needs to happen in order for them to reach a settlement. And they end up settling the next week or within the next month because of the way that you've done mediation. Now, there are a couple of ways of doing mediation, and we teach a very specific way of facilitative mediation where we focus on the people that are there. The problem is important, but the people need to be taken care of properly during the mediation process. And then by the end of the mediation process, they get to a position where we can restore the relationships between the two parties. We can get parties to sometimes even be better off than what they were before the conflict started. Now, if you have a look at the mediation process and what is required, for our legal professionals course, you obviously would preferably need a legal qualification. In South African terms, if you have a look at what is required to become a accredited mediator with various societies or accredited mediator in the eyes of the state when it came to court and next mediation, we haven't got confirmation of the exact new rules that's going to be put in place by Gauteng and so forth, the requirements for that. But the minimum is that you have a matric exemption, you are 18 years and older, and that you don't have a criminal record. So you can see that you can have a vast array of different people becoming mediators or even claiming that they are mediators, because nowhere in the stipulation it said that they have to have completed training or belong to an organization or any of that. There's also at the moment no regulation on training organizations, which is a little bit of a problem. I think if you are going to be selecting your mediators, go and have a look at the mediators that have got at least some sort of accreditation with an organization like DISAC, for instance, dispute resolution there are very other organizations, FAMAC, that does family stuff. DISAC is more the commercial side of it. But there's no overarching body controlling mediation at the moment. We are working on it behind the scenes, and hopefully we'll have solutions for you in the near future. But go and have a look at accredited mediators that belong to organizations like Mediation in Motion Mediators. I know that Conflict Dynamics have got their own group of mediators that fall under their own panels. There'll be mediators that belong to FAMAC, SAMA, and so forth. You can have a look at those organizations, mediators, in order to fulfill your mediation needs when you need to go and approach somebody to find a mediator. Now, as I said, we have been working with the University of Cape Town for the past 11 years. The training course that we present follows international best practices. I know that I've got confirmation that if you go to Scottish Mediation, they'll accept you as a mediator after having done our legal professionals course, which exceeds the minimum requirement that they have. It also exceeds the minimum requirement that a lot of other countries have to become a fully fledged mediator. We have drawn extensively on our training material from international happenings, mediation in the UK, mediation in India. Just a quick note on Indian mediation, it's actually kind of run by the judges and it is enforced by the judiciary. Unlike what's been happening in South Africa, is where it's a voluntary process. It'll probably always remain voluntary. The outcome, staying there until a solution is reached. But I think they're leaning more and more towards that people should put on a valiant effort to try mediation to resolve the dispute before they're going to be giving out court dates. It looks like everything is moving in that direction. And I think the sooner people can do mediation training, and the difference between mediation advocacy training and actually mediation training that aims to get you to become a mediator is, we found that a lot of the concepts that we teach in the 5 days, they don't take root and they don't get understood by the delegates up until day 3 for 90% of them, and some people day 5 only. They really truly understand the concepts and they can properly advise people, their clients, if they are attorneys, about mediation and the pros and the cons to that after quite extensive training. Your one day, this is mediation training, or me speaking to you about mediation and quickly trying to run through the differences between negotiation and mediation doesn't give you a full understanding of the actual capabilities that mediation has. And it takes people quite a while to get that. So we do provide mediation advocacy courses. We've started doing it less and less because we found that it isn't really effective, and people need to go and attend a 5-day course. Not saying come do Mediation in Motion's 5-day course, but go and do a 5-day course in mediation from a reputable institution in South Africa. I've done multiple mediation courses, and the one that I did was a complete waste of my time. Spent 5 days and 40 hours trying to learn how to become a mediator, and it was completely ineffective. So I would urge people to go and do their research and sign up with decent institutions to go and do their training to get a really good understanding of what mediation is about. What I would like to do is just tell everybody there should be no reason for you not to advise your clients to go to mediation if you don't understand the process. If somebody requests mediation, it is cheap compared to running a full litigation process or preparing for your days in court and then settling on the steps of the court. You can help your clients get a mediator within days rather than sitting there. And I heard yesterday that Gauteng has now moved into 2031, which is sad. I mean, if you want to get a court date and you've got to wait that amount of time for your parties, it is a little bit sad. There are panels of mediators that will probably get you a mediator within a day or two if you really need something resolved very quickly. And I would urge everybody to do that. Now, as I said, we have got specialized courses coming up for advocates and medical professionals. We do contact courses, but we only do it in one location at the moment. That is down in Paarl on Advocate Nelson's farm. It's got great training facility with lovely accommodation, and it is experience being there for the 5 days. And it helps people, I think, to attend these contact courses, get away from the office, because what happens if you're close to the office, you feel the temptation to pop in and do some work. And you can ask people who've done this training. It is very intense. You actually do not have the time to go and do other things in between. Your time, especially for a 60-hour course, is completely consumed by this course for the 5 days. And that's why we only run it over 5 days. We don't spread it out longer. Week is long enough, is more than long enough for a legal professional to spend their time learning new skills. And it is definitely something that changed my life when I did my mediation courses, how to deal with conflict ourselves, how to help people that are busy with conflict, and just how to find out what parties actually really need. Your clients that come to you, just in the way that you ask a question, find out what their true needs, interests, and concerns are. And sometimes we look past that. Unfortunately, we've been so ingrained in what their legal position is, we forget about what their true needs, interests, and concerns are. So just be mindful of that. If you are interested in mediation, we are always willing to get people to come and attend courses on the farm. We do offer mediation training courses, still very good. Presented the same courses, they just presented via Zoom online, like we are on Zoom now, and you get very much a similar experience, except for a little bit of the social interaction and the other experiences surrounding being away from a house in a beautiful venue down in the Western Cape. It is virtually the same training that we are doing. We make use of the same trainers, we get in the same coaches and all of the same things. So we've got 2 courses coming up, the 31st of March to the 4th of April. That would be contact on the estate, specializing in medical negligence. But as I said, the fundamental skills are transferable to other spheres. And the next course that we have is on the 7th to the 11th of April, which is an online via Zoom advocates, attorneys, and other qualified legal professionals course. We have got many of them scattered throughout the year. I can ask that. I don't know if there's a mailing list. Yusuf, you can let me know if there is. I can get my lady to just forward you the upcoming dates and attach a couple of the brochures there for you, if you would be interested in that, to inform your members.
Thank you kindly. Yep, that would be absolutely brilliant, and we'll get it out to everyone on the list. Thank you.
Excellent. Excellent. Thank you very much. So I think that would wrap me up for now. I don't want to take up too much of your time. Do you want to do questions and answers now, or wait until after Michiel is finished to do that?
I think we'll wait until Michiel is finished, and then we'll do a Q&A or roundup comprehensively. Thank you very much for that in-depth explanation. And time in Paarl sounds wonderful.
Yeah, it'd be lovely to have you there. So you're more than welcome.
60 hours seems like there's not enough hours in the day. It looks like a very intensive course. Thank you very much, and we'll now move over to Michiel. Michiel,
thank you so much for the opportunity, Yusuf.
Absolute pleasure. We'll reserve you for Q&A in a few minutes' time. Michiel Bauer, please kindly introduce yourself shortly and tell us more about the Mediation in Motion, the entire model.
Thank you, Yusuf, and thank you for the opportunity to introduce Mediation in Motion mediators to the members. I'm Michiel Bauer. I'm a practicing attorney, litigation attorney, primarily commercial litigation specifically, and I'm also a Johannesburg Attorneys Association and thus GAA member. So it's nice to be speaking to my colleagues and co-members in my capacity as a mediator today. And perhaps I thought I'd start with my story and my introduction into mediation. About 10 to 15 years ago, I had a very complicated commercial matter where we had a family business that didn't have the relevant documents in place, and there was a deadlock between two brothers that made the functioning of this business impossible. You know, I didn't really know how to solve this. There weren't agreements in place. I was acting on behalf of the company, so I needed to act in the best interest of the company. So I proposed that these two brothers go to mediation, and we end up at a lawyer who, you know, like Daniel said, can mediate because he fulfills the legal requirements, but he wasn't trained as a mediator. And that actually ended up making the entire dispute worse. And that business, despite it being a world-known, well-established business today, is liquidated, not because of financial problems, but because of a family dispute that was insurmountable. Past 10 years, I have another very complicated commercial matter. We are in urgent court. We obtain an interdict, and the interim interdict is in place, and then we're like, okay, well, now the matter needs to be referred to commercial court. It's restraint of trade, it's complex, it's corporate espionage, and our counsel proposes that why don't we refer this matter to mediation? And we do, and we end up with Alan Nelson, Advocate Alan Nelson, SC, as our mediator. And over the course of the next 2 days, I saw something that I'd never seen before, and I saw people's attitudes being transformed. I saw their dignity violations being addressed. I saw them shift their hardline positions. And after probably spending around 1.5 million in legal costs over the course of 2 days, they not only resolved the dispute, but we're even talking about things like mergers, cooperation agreements, and the like. So that's on a massive corporate level where people took things personally, and it got ugly, and mediation just changed it. And I walked out of that mediation on the second day, and I said, I want to do this training. I want to do this specific training. So I located it, found out the affiliation with Mediation in Motion, and I decided to go and do the training. Now, I did the training down at the farm. I would highly recommend it. If I had to do virtual training and still be interrupted through the course of the day, as one often gets in practice, I think it would have been very difficult to get through that week. It's incredibly intense. You are intellectually engaged the entire time. We start about 8 in the morning, finish at 10 at night, and then you've got preparation to do for the following day. So I encourage the members to consider that. It's a nice trip. It's a beautiful farm. It's out there in the winelands. So for us Gauteng folk, it's really a treat, and a business trip at that. So tax deductible. If ever you saw one that was worth your while. So that brought me to mediation. I went for the training, and I've since then been really passionate about mediation. So also after having successfully completed the training, I then joined Mediation in Motion Mediators, and I'm currently the vice chairperson of Mediation in Motion Mediators. So what MIMM does is it's a not-for-profit organization, firstly, and we're dedicated to raising awareness of mediation and advancing the practice of mediation. It was initially formed to represent mediators who have completed the Mediation in Motion training. And we serve as a platform to connect trained mediators, share ideas, collaborate on creating new opportunities for mediation. We're also dedicated to promoting mediation as a viable and preferred alternative to the traditional dispute resolution methods. And we, are passionate about emphasizing the benefits both to the parties and to the broader legal system. Because really, the fact of the matter is that if you go by the maxim that justice delayed is justice denied, we do not currently have any justice in South Africa. Because to take 5, 6, 7, 8 years to get to a trial, and sometimes wait another year or two for a judgment, that's not justice, and it serves nobody's interest. So I think if some of the matters, those that are capable of resolution by agreement between the parties, can be removed from the court system, the matters that do need to go to trial will get there and will get there quickly. And I do not believe for a moment that it will take work away from our profession. I think it would probably increase work if you give your clients good outcomes and good results and do it quickly and cost effectively. They are going to be coming back more regularly for matters that ordinarily would have fallen by the wayside. So in addition, obviously, for legal professionals in particular, there's this opportunity to train as mediators and to become mediators and to assist with the complicated legal matters that are referred to mediation. Now, to add to what Yusuf has said, and I know there's been 2 previous feedback sessions, the reality is that it's been on the cards for a while. I identified it about 3 or 4 years ago as a reality that's coming our way with the introduction of Rule 41A, that court-mandated mediation would be a reality. Now, mediation is a voluntary process, and there's a lot of murmuring about how can you be mandated to go to mediation if it's voluntary. There's a 2005 Constitutional Court judgment by Judge L.B. Sachs, where he refers to, I think it's the PE municipality matter. And there's a passage in that very judgment where he says the referral to mediation might be the mandatory part, does not make mediation involuntary. Nobody can force you to arrive at a settlement, but you can be forced to try. Can be forced to go to the negotiating table or the mediation table, attempt mediation, see if there is the possibility of resolving the dispute or at least narrowing the issues, alternatively agreeing on timelines and procedures. There's a lot of scope for those things to be attended to. So there really is nothing to lose. If a mediation fails completely, you are no worse off than you were before the matter got referred to mediation, but for the costs of the mediator. Now, mediations take complex commercial mediations 2, maybe 3 full days. Some matters, a lot of the medical negligence matters take about half day, 3/4 of a day, maybe a full day. You spend 1 or 2, maybe 3 at a stretch days, really working hard at trying to see if the parties can come together, and that's it. And the cost of the mediator pales in significance. It's usually shared between the parties, so it's not nearly as expensive as a trial would be for the client. So it's really worth the effort, because the upside is that you arrive at a settlement and that your client is delighted. Now, Daniel used the example of the pie and sharing the pie. There's a equally good example of 2 children fighting over an orange, 2 siblings specifically. They fight over an orange, and they run to their parents and say, you know, we both want the orange and there's only one orange. So what do we do? Now, the negotiating part of me just says, well, the simple solution is cut it in half. But the mediator would ask, well, what do you want to do with the orange? And the one says, well, I want to bake a cake, so I need the skin, so I can get the zest for the orange cake. And the other one says, well, I want to squeeze out the juice. So all of a sudden, you've got a solution that serves both of those interests, because the one can get the skin and the other one can squeeze out the juice. All of a sudden, you've solved two problems and you've have two happy kids, where you would have had two unhappy kids, because those of you that do have children will know they are not particularly susceptible to sharing with their siblings. So that's what mediation can do. To, I suppose, close off, Yusuf, is to maybe say, how would you go about getting the appointment? The fact of the matter is that probably you would have shared with your members that mandatory mediation is I think Sutherland said the ship on whether there will be compulsory mediation has sailed. There will be. So to get a mediator, you can go to our websites, mimmediators.co.za. There are links on there about, you can scroll through the mediators. Now, we've just transitioned to a new web page. We're still getting over all of our members. So it currently looks as though there aren't many. There are more than enough mediators. MIM Training has trained over 700 mediators. The other organizations have trained thousands. The problem to date has been opportunities to actually gain practical experience, and with this there will be. So you go to the website, you can scroll, you can select a particular mediator or just ask for the appointment. Alternatively, you can send an email to info@mimmediators.co.za. Thank you.
Thank you kindly, Michiel. That was quite in-depth, and thank you for scaring us one more time into reality that this is on the doors and we're just waiting for the practice directive to be issued upon us. We have a number of members online, which I'm sure they're dying to ask us many questions. We're now opening the floor for the Q&A part. Can we please raise hands, and can I please ask my secretary, the secretary of the GAA, if she can co-check for me if any questions are arising. In case I miss you, just switch on your camera, might be a good way to identify us. Aaron, please continue. Ask your question. Please go ahead. Mr. Sibanyoni.
Sorry, yes, I was just unmuting. My apology. Good afternoon, everyone.
Afternoon.
Right. The questions that I would like to find out from the panel. Thank you very much for that informative sessions for those two mediation institutions. Something that I would like to ask is that I just want to get some clarity whether the current process to address backlogs by the South African Law Commission, including the recently released Mediation Act paper, is aligned with the court rules and directives dealing with mediations, which I understand are still under discussion, or if they are working in parallel. I'm interested in understanding how these efforts coordinate with each other, if there's anything, if somebody knows about that. Thank you.
Thank you, Aaron. Michiel is leading in our judicial subcommittee. Do you want to just address this particular question?
Yes, sure, Joseph. They are very closely aligned. We are actively also, it's another part of what Mediation and Motion Mediators does, is that we participate in these processes. In fact, there's a workshop tomorrow, the entire day, with the South African Law Reform Commission that I'm attending along with a number of my colleagues on discussion paper 168 on Project 94. So we've got a proposed mediation bill for South Africa. Those that are au fait with the legislative process will know that it will be several years, if not at least a decade, before that becomes an act, and then we'll have to wait and see how long before it becomes enacted. In the meantime, we are aligning with international standards. We've very much followed the Singapore model. So if you want to go look at what's happening in Singapore, that would be useful. But what is being agreed upon as accepted standards for accreditation in South Africa and for qualifying for the purposes of this process aligns both with the proposed bill and with international standards.
Thank you. Any other questions?
Thank you.
Rising? Mr. Murray, please go ahead. Mr. Murray, you got your hand up. Please go ahead and ask your question.
I just wanted to know from Mr. Nelson whether mediators get paid per assignment or per hour.
Okay, generally speaking, how it works for me, but everybody can probably get their own systems in place, is that we get booked out on a half-day or daily rate. You can have a per-hour rate. Mediation is not something that happens within an hour, generally speaking, even though it's very quick. You'd probably take half a day to a day on most of your matters. About 70% of matters are resolved and settled within 1 day's mediation, and another 20%, so for a total of 90%, they do find settlement after that. So mediation is 90% successful, with most of it, 70% of it, happening within 1 day. So we normally work on a half day or a full day rate that we charge for mediation.
Daniel, just to elaborate on that same question, do you actually bill for preparation time and reading on large matters, or is it just for the day?
Okay, so generally speaking, on mediation, we don't have to prep in the same way as you would prep for a court case. So our prep time is a lot less. Certain matters you do need to spend lots of reading time, and you will have a perusal fee for that you can charge people. Generally speaking, if it's going to be taking me less than an hour to prep for a full day's mediation, I do not charge a preparation fee. But if it goes over that, there would be a perusal fee included into reviewing all the documents.
Thank you very much. Nicolette, your hand's up. Please proceed.
Thanks, Yusuf. My question ties in somewhat with what we've just discussed with Daniel. Daniel, I want to ask you to maybe just elaborate a little more regarding the role of the attorney during mediation. And my second question is whether our client can give power of attorney to his attorney to attend the mediation on his behalf in total.
Nicolette, thank you for that question. Very insightful. We do teach our mediators to deal with attorneys and what is expected of attorneys during mediation. The mediation process doesn't ignore attorneys, but it is focused more on the parties themselves. So your job there is to properly legally advise your client, because the mediator can't do that. Is one of your main roles during the mediation process. But it's also to help your parties understand and help them to, when the mediator is not with them, to iron out what their true needs, interests, and concerns are. So it kind of helps the mediator at the end of the day. When the parties come back, they've got a better understanding of, well, I asked for this because of that, X, Y, or Z. So you are very much needed. And I always say, when we get to the negotiation phase of a mediation, I like to have attorneys present. Comes a time when we've got to start drawing up agreements and so forth. You've got to advise your clients on what they should do, what is best for what is in their best interest. And you have to do that during the negotiation phase, We've got to very much focus on that. So attorneys, I like having attorneys present. It gives me a little bit of comfort. They are there to look after their clients' rights and give them the advice. I would strongly advise not to get the power of attorney and represent your client at the mediation, because ultimately you haven't asked the parties the right questions to understand their true needs, interests, and concerns. And that is where the focus of the solutions in mediation lies. It is different to what you have been doing up until now. And if you've got power of attorney, you're going to be representing your client based on the facts that they've portrayed to you, or based on the facts that you've read up in the matter. And it's not really looking after their needs, interests, concerns. I've always said, people say, oh, no, we're going to get to money. There's going to be money involved. So somebody's got a knee operation that's gone wrong. If you give power of attorney to an attorney or to somebody else, they're going to fight about how much gets paid out at the end of the day in order for your party actually to go and have a knee operation. But what if we can't get that knee operation as one of the options on the table? It reduces the monetary amount. But if we can get the knee operation on the table for next week, is that more beneficial than waiting 3 months to 6 months to get a date for that operation to happen? So I strongly advise having the parties there, because we can discover things that haven't been canvassed as mediators. So that's why I would advise not to get power of attorney and go represent your client at mediation. The clients must be present.
Thank you for that, Nicolette. That answers both your
Thanks.
questions.
It does, yes, Yusuf. I see we have quite a number of questions coming in on the chat, and we like things being a bit more interactive. So I want to propose, guys, that you please put on your microphones, raise your hands, and ask your questions. Otherwise, we've got 2 streams going. And it's great for the recording as well to have the questions on the audio. So please, guys, that posted on the chat, won't you come in and ask those questions here?
Nicole, do you want to start? You had a nice question on the chat.
Oh, hi. How are you all?
Well, thank you. Please go ahead.
Good. I had a general question about if there are enough mediators fit for purpose, primarily because it seems a lot of the mediators have had their hand in commercial matters and family law matters, where I think that the issues with RAF specifically are quite nuanced. We're all familiar with what we deal with on a daily basis, and listening, I don't know if we can address it in that way. So I'm just a little bit curious.
The availability of mediators, RAF specifically, my answer was that I have little doubt that there are more mediators available than there are RAF case managers that are able to attend the mediations. So that I think is not a problem. Like I said, the problem with mediation thus far has been that you go for training and it's hard work, and it actually ends up costing a lot of money to create mediation opportunities because of the resistance, and that there weren't these pre-established channels. That's no longer a problem. You will now be able to train and then become actively involved in these initiatives from day one. So if the problem is that there aren't enough mediators, just over those 2 weeks, March, April, we can add another 50. So I don't think that the supply of mediators will be a problem. We have a few hundred mediators affiliated with MIMM, and even more with some of the other organizations in the country. I think that there will be enough. On the field of family law, mediation is well established. There are many family law mediators out there that have been practicing successful and that have full-time mediation practices. In the civil and commercial sector, it's been very tough to be a full-time mediator exclusively. You have to keep on litigating to fund the mediation passions, as I'd like to call it, specifically because of the value that mediation adds to dignity. So there are plenty out there. It's the opportunities that have not been available, and it might take some time to clear the initial clogging. I think it won't start off with 700 mediations in the first week. It's going to be maybe 15, and the next week 50, and then it will increase from there on.
Thank you. I do have a hand raise. Kalipa Mafungo.
Hi, thank you, Yusuf. I just wanted to get clarity. If you've attended, the Arbitration Association offers a course for mediation by Jonathan Dingle. It's a 5-day course in facilitative mediation. Would you then be accredited as an MIMM mediator? I think that's for Michael Michel.
Yeah, so we are currently working on a policy for recognition of prior learning. I happen to know that the AFSA course, they've recently applied for DISAC accreditation, and it aligns with the international standard. I know Duncan Turner, who's I think head of the mediation program. That course does comply with the training requirements you would need to meet, and the recognition of prior learning is under discussion. We actually have an EXCO meeting this evening, and it is an agenda item. So you would comply with the general requirements to attend to court and next mediation by virtue of having completed that course, but for that you might need some experience. The talk has been that there will be provision for observers to take part specifically in RAF mediations. There's also a SAMLA initiative with the Gauteng MEC for Health that's been very successful. So getting involved with that also creates experience opportunities. So you would likely qualify, and like I said, that we're in the finalization of that recognition of prior learning policy.
Thank you kindly.
Perfect,
Charlene,
thank you.
please go ahead. Charlene. Ms. Labuskachny, please go ahead. Can unmute. All right. Any other questions that we have at this moment in time? We're coming close towards the end. This is an opportunity to ask some questions. While we're at it, can you tell us about the various, at this moment in time, it appears as if both commercial matters are also going to have to undergo mediation in terms of what the proposed practice directive is. So MIMM would have the facilities to provide to us commercial, family law, medical negligence, and contractual disputes. Is that correct? Mediators, you'd have enough mediators for those particular matters as well.
Yeah, so currently the system in South Africa works that you've got civil and commercial mediation as a sector, and then you've got family law mediation as another sector that falls under NAVFAM, the National Accreditation Board for Family Mediators. DISAC is the Dispute Settlement Accreditation Council. So I know that Daniel didn't get on that name earlier, but and then there's an umbrella body that's been recently established and is in the process of being developed that's known as the ADRPSA, the Association of Dispute Resolution Practitioners of South Africa. So the mediators in the family law field, more than sufficient. Some of the MIMM members are accredited as family law mediators. There you can filter through mediators by field and select your particular discipline, but certainly in the civil and commercial sector, more than enough mediators available. I think that once again the reluctance has been on the side of the referral, and the difficulty in commercial matters is that you need to get a person with settlement authority, so likely the CEO or the MD or a delegated board member to attend in person, and they really do need to be there for a full day or two. But certainly the mediators aren't the problem.
Thank you. Now let's deal with a scenario where the Road Accident Fund, for instance, or another defendant does not attend the mediation and it's all been arranged. As far as what the draft proposals go, in terms of what we think the practice directive is going to indicate, to obtain a certificate in that regard, would that be an easier said than done? And then we can move back into the trial scenario.
That's a loaded question, Yusuf. It's I suppose we have to wait to see what the directive says. I anticipate that we brought it to the judge's attention that is a likely concern, and that may happen. There may also be some instances of a party simply not responding, not cooperating, recalcitrant litigants. And, you know, some of us know that we've all had to at times also be the recalcitrant one in order to maybe buy some time or delay proceedings somewhat, unless you've only always acted for plaintiffs. So don't hate the player, hate the game. I think that you will encounter that, but you're currently dealing with it in a much more significant way. I do think that the directive will or should provide for that. If I remember correctly, it's going to be published for comment first. So if it's not in there, I certainly will be commenting to that end.
Well, thank you very much. If there are no further questions, I'd like to sincerely thank both Daniel Nelson and Michael Bauer for their time. I would also like to thank Aziz Ismail from Baker McKenzie for hosting this workshop, the executive of the GAA, and in particular, Nicolette de Wit, Conrad van der Vijver, Marianne Pretorius, Vijay Tarana, Tia Newbert, who is present, Chantal Gladwin-Wood, Mali Chantal Luri, and the 4 attorneys associations and their executives for the countless unbillable hours spent for the benefit of the profession. Please keep a lookout for further development in this particular field, and the GAA will be hosting, I'm sure, many informative sessions coming up soon. Sincerely, Michael and Daniel, thank you for your kind time. You've made it easier for all of us to try and ascertain how we go about in the mediation process and actually open the doors that we should not be too scared if this practice directive does come out. Sincere thanks to all our attendees, and it's been a privilege. Thank you for the privilege of your time. All the best. Bye-bye.
Thank you, Yusuf. Thanks, everybody. Bye-bye.